very interesting day. You know, with COVID and everything that's happened, we've had a lot of, it's been the catalyst of a lot of change. And we have had to deal with many different things in regards to how to react to this, not only on a personal level, on a professional level as well. And there's a lot of activities that the country is doing, changing laws, so on and so forth, that affect a lot of that. So this is like perfect timing right now. And we're very, very thankful to the Tamimi Company and Philip Kotsis, which is one of our board of directors, for taking the time out to go through some of these legal issues with us to help us in our not only personally, but professionally and for our companies. So thank you very much ahead of time, Philip. We really appreciate it and welcome everybody. Thank you, Paula.
Thank you so much, Frank. And again, good evening to everyone, and thank you for joining us this evening. Since we have a few non-ABCK members, we'd like to just give you a brief of what we do as a Chamber of Commerce. So ABCK-AmCham Kuwait is a nonprofit organization which is comprised of small to large corporations as well as prominent business leaders and entrepreneurs, both American and Kuwaiti. Through the support of our members, AmCham Kuwait has become the recognized voice of U.S. business in Kuwait, and our main goal is to support Kuwait in leveraging business and industry to find creative, effective solutions to the challenges that Kuwait faces in this time of crisis, in its recovery, and in achieving its new Kuwait 2035 vision. If you'd like to learn more, you can follow us on social media at ABCK1985 or contact the membership manager, which is myself, at membership@abckw.org. Now, a speaker for this evening is Mr. Philip Kotsis. Mr. Kotsis is a partner and co-head at the Tamimi Company Kuwait office and is the head of corporate commercial department in Kuwait. He is a U.S. qualified attorney and has accumulated a broad range of experience in areas of local and transitional commercial and corporate transactions, corporate establishments, mergers and acquisitions, corporate joint venture organization, banking and finance, as well as substantial experience in the commercial and finance aspects of Kuwait PPP projects. Additionally, he is known in Kuwait for his vast skills in complex restructurings, corporate and debt related, as he has been deep involved in Kuwait's large infrastructure projects, including water desalination and power generation plants and wastewater treatment plants. Mr. Kotsis is consistently recognized and awarded by top global ranking agency as a leading lawyer in Kuwait and is widely known in Kuwait for his expertise in his areas of practice. Mr. Kotsis, the floor is yours.
Okay, thanks, Paula. Thanks, Frank. Look, it's a pleasure to be here tonight, and I appreciate everyone taking the time to join us and discuss a little about Kuwait law and an update on what's going on in the country. Thank you also to the German Business Council who is joining us as well. As Paula said, I mean, the introduction was quite long, but my name is Philip and I'm a partner here at Tamimi Company. I've been in Kuwait for 11 years and I co-head up the office here. And today, the purpose of the webinar today is going to be to provide you with a brief update on a handful of new developments that are going on in the Kuwait legal sector. So the first thing we're going to just briefly touch on is since COVID-19, there's been eyes on the law and changes. And the goal here is just to kind of give you an update of what we've seen lately that's come out and since the pandemic has hit Kuwait. We're going to go over the labor law and see if there's any updates there, the rental law, leases, force majeure, visas, work permits, the new lockdown, anything there. And go into things of that nature. After that, I'm going to spend most of the time actually to discuss briefly, touch upon two new laws that are coming out in Kuwait. One is the new bankruptcy law, and the second is the new competition law. So the new bankruptcy law has not yet been formally published, so it's not yet got the force of law, but it is expected to come out, and the new competition law has been published, and that is going to be law. It is law as we speak. So I'm going to focus mostly on those two, but provide you some updates. And to start, so what have we seen? So we saw, this spring, the pandemic hit and a number of things happened in Kuwait, including the lockdowns. And so over time, there was a lot of buzz in the legal field to see what was going to change in the law in terms of how things were going to go. And the main laws that we were concerned with, I think, in the beginning and throughout the summer were the labor law and the law in relation to visas and work permits and force majeure. Those are the major ones that we discussed, and I think we probably had numerous. You probably attended numerous webinars in relation to these type of things. And we thought we were going to see a progression over the course of the summer and into the fall of major changes, but we haven't really seen that. That's kind of been an interesting movement that's happened, is not to see much movement in those areas, especially in the labor law. There was a lot of talk, a lot of buzz about labor law changing, whether it was going to, relieve the employers of the burdens that are of the Kuwait labor law, or whether it's going to give more benefits and protections to the Kuwait employees, or if there's going to be some balance on that. But we really didn't see. We saw a lot of discussion, but we saw at the end of the day there wasn't much that was issued in terms of labor law. And the major things there that we saw, were speculation, and the same basic things that boil down to is when we're stressed, when we're in these situations, when we're in lockdowns, what happens? We have any relief from these laws. The general rule is you keep following laws until something has been amended or changed. And so we did not see, relief to employers in terms of, reducing salaries or forced annual leave and things of that nature. So we did not see things like that. In fact, all we did really see is that there was some benefits given to companies to help their Kuwaiti employees in terms of putting them on a system where the government would subsidize them for a 6-month period. But in terms of everyone else, you had to follow the labor law. And so that put a lot of companies under a lot of stress. And they've had to make do with what the law has. So one thing to note is, even in times of pandemic and crisis, you don't always see upticks in laws or amendments. Obviously, there's calls to action, but in Kuwait, the first thing to note is that there's constant issuance of new laws and decrees and regulations, whether it's healthcare related or with its capital markets authority, whether it's competition law or with the central bank regulations. There's always new things. So we're trying to focus on today some of the hot topics. If we go to the labor law to start with, little in the way of changes in the labor law. There was speculation, like I said, of major changes, both from the employee and employer perspectives, but nothing has really materialized in terms of that. There have been some work from home guidelines that have been discussed, but not yet issued in terms of formal laws or decrees. There was a ban, as most of you know, from government to private sector. So the transfer of visas from the government to the private sector was prohibited. And the current state of the matters, our business and visitor visas are still generally not being issued. And so the formal position on it is they're not being issued. There are some that have been issued that we've been aware of, some companies, and this is basically just on a practical approach to things. But from an overall legal approach, you still have the issue of issuing new visas, whether they business or visitor to companies, especially when they're trying to bring in workers to do projects. And that's become an issue for a lot of companies. And it looks like it's still going to become an issue in the months to come until we work our way out of this pandemic. There have been complaints made to the Public Authority for Manpower and to the SHUN during the lockdown for things that have happened during the lockdown period, for complaints. And we've seen a serious uptick in the number of those complaints with the Public Authority for Manpower. And it looks like they have been actively addressing these situations. What we have seen on the ground is that when you have a company that has a lot of complaints, they take a more forceful action with that, and they do look into it and they try to resolve the issues as quickly as possible. And this is mainly for issues that have raised during the period of time during the summer when they were locked down. Not so much going forward after September, because at that point you're back to pretty much. In terms of leases and rents, we saw a couple things happen. There was the new rent law amendment, or the lease law amendment, which makes a distinction for actions that were taken during the pandemic period, as decided by the Council of Ministers. So where there's a period of time during the pandemic that the Council of Ministers had determined was a period of action, this new rental amendments apply to that. In other words, during this period of time where the Council of Ministers have said, from period A to period B, we are going to give some relief to basically renters, to give them some relief from their rents and things of that nature. Under this new amendment, the court will have discretion in determining the methods of paying late rent during, again, these periods of cessation of business as due to public health, as described by or as dictated by the Council of Ministers. This is not generally to all periods of time. Like I said, it's within periods of time where business was ceased due to public health issues. This doesn't mean you get free periods of rent. What this means is that payment of rent will be altered and decided upon in an equitable manner by the court to help relieve the burden. Amounts that are owed prior to this period or after this period would not likely be included within this relief. And the focus on the period where the government ceased business due to public health concerns. Again, not periods before or after this major pandemic time frame. It's created a single judge rental division that will be established shortly within the courts. They'll have the sole jurisdiction over these leasing issues. It removes it from the general court system, which should alleviate pressure on the system and provide special attention to these types of claims. And I think the other, you can move to the next slide. So the other types of issues that we're seeing in the beginning were a lot of discussion on force majeure and exceptional circumstances. Nothing has changed in terms of the law, but what we're starting to see is on the ground lawsuits being filed, claims being made that have claimed force majeure or exceptional circumstance type situations. Again, to make a very quick distinction, force majeure is an impossibility situation. Something has happened that has rendered the contract basically impossible to perform, and therefore the goal is to end the contract, to put the parties back in the position they were at the beginning. Where exceptional circumstances is a situation where things have changed in such a manner that does not necessarily render it impossible, but it's extremely burdensome, and that it offers some relief to the obliged party so that it can, in terms of whether it's increasing fees or reducing the obligation to pay in certain circumstances based upon the situation. Like I said, we haven't seen changes in the law in terms of force majeure and exceptional circumstances. They're going to stick with the civil code provisions in relation to that. However, we are starting to see in the courts these cases starting to be brought, and it'll be interesting to see how the court interprets these cases over the course of time. This will not be an instantaneous thing. So even before, when you're at the court of first instance, and you have these cases, maybe it gets done within a year, maybe sooner, but you're still going to work your way up to the Court of Cassation, all the way up to the Court of Cassation. And until then, we might start seeing at that point how the courts are interpreting and applying force majeure provisions in Kuwait. Again, visa work permits, I discussed those quickly. There's really no more update on that other than right now it's continuing. There's a cessation on the issuance of the same. And the new lockdown is the new latest thing that we've seen. Whether or not you subscribe or you follow Kuwait Up to Date or anything else online and social media, you've seen, issues related to that. From a legal perspective, there's nothing been issued yet. Obviously, you'll hear it as soon as I hear it as well. So it won't be a surprise when you hear it because everyone heard it at the same time. So whether or not they go into a new lockdown or not, we don't know yet. But we'll all find out together. And again, when that happens, issues regarding rent, employee situations, and force majeure type situations probably creep back in. So that's a brief overview of a number of the major hot topic areas over the past few months. And like I said, there has not been as much movement. There has not been as much movement as we thought there would be in some of these laws. However, there has been minor movement in these things, such as the lease law and some issues related to labor, but not the major fundamental changes we thought might come out of this. But there have been other key things that have happened within the law. And this is not related necessarily to COVID, especially these two laws that I'm going to talk about next, although one kind of fits within it because we're going to see a lot of stress on businesses that have been brought about by the COVID crisis, and that's the new bankruptcy law. So the new bankruptcy law was agreed upon in September of this year. It was approved by the Kuwait Department, I should say, in September of 2020. This is when they approved it, but it's not yet been published in the official Kuwait Gazette. Therefore, it does not yet carry the force of law. Previously, there had been no independent or specialized bankruptcy or insolvency law. So this is a much welcomed and needed law that is on its way to being passed, assuming it goes all the way through and gets published. So we fully expect that it will be. Prior to this, the bankruptcy provisions are codified and encapsulated within the commercial law. There was a financial stability law, which is still in place, but it was seldom used. We know one clear case that was used under the FSL, but it was not proven to be useful or practical, and we did not see a lot of use of that. So besides the bankruptcy provisions in the commercial law and the seldom used FSL, you did not see a lot of use of the bankruptcy system in Kuwait. And historically, most insolvency situations were resolved through consensual restructuring of the debtor's liabilities. So it was agreed upon between the debtors and the creditors of how to deal with these situations. You didn't see a lot of forced bankruptcy situations. Market participants did not want to rely on untested legislation. There was a general stigma on bankruptcy and insolvency proceedings in Kuwait as opposed to other countries. For example, where I'm from the United States, there's really not a stigma to it in terms of maybe personal, but in terms of corporate, it happens all the time. And just because you go bankrupt doesn't mean your company is going to be folded up. There is restructuring and there is rescue and there's all types of things that go with it. You just didn't see a lot of it in Kuwait. Workouts, liquidations, debt restructurings, they were all quiet and they were done, really between the parties involved and did not involve the courts. At least they tried to avoid the courts as much as possible. So the new law is a major step forward. It was influenced by other insolvency regimes in the region and applies international insolvency trends with this new law. Better than the encapsulate just in one part of the old commercial law. It was one section of the old commercial law. Now it's its own independent standalone law, or soon will be. It streamlines and modernizes the bankruptcy insolvency provisions. There's an emphasis on early restructuring of indebtedness and distressed companies rather than waiting to the point where it's too late. So they want to see workouts. They want to see the ability of companies to come out of a distressed situation. So you hit it early rather than waiting to the end where there's really no hope. There's an attempt to destigmatize the business failure and therefore lead to a change in the business culture and an improved climate for investors. So where you have a regime that encourages workouts, encourages a structure where it doesn't mean bankruptcy is a horrible thing, it's going to change the business culture within the country to improve not only the view internally, but externally from investors who look into Kuwait and say, okay, they do have a regime that's in place, that's modernized, that will help the situation if the company is distressed. At the end of the day, it's all going to depend upon how the law will be used and implemented in practice. And of course, the willingness of the business community and practitioners to take advantage of the new regime. So that to the extent that no one uses it, then it's useless. So what we're hoping for from a legal perspective is that the business community will embrace it and use it, because you have a lot of situations, especially now when you're coming out of a COVID crisis or a pandemic, which is unprecedented. We always have the ups and downs of the economy as we always go through, whether it was the global financial crisis in 2008 to 2010, around that era, or the pandemic now. You always have these up and downs, and some companies do, manage to succeed through these. Some float by and survive, and some really are forced to take new directions. And so hopefully this allows a number of companies to really look at their situation, allows creditors to look at things and not just say we need to liquidate immediately and force litigation, but look at an alternative way of recovering this company. I'd say there's two key aspects that we're looking at. And first is the new law does not treat failure to pay debt as a criminal offense, unless of course it's due to fraud. So unless there's some fraud involved in terms of the debt and its failure to pay its debt, it's not looked at as a criminal situation. It's a business situation. This is how most countries treat bankruptcy situations. Second is the law allows bankruptcy to be avoided by either a settlement with creditors or a restructuring plan. So that's part of the bankruptcy law itself. So bankruptcy law isn't just saying we're going to go in, we're going to liquidate, and and we're going to pay out the creditors, but it also says we're going to try to avoid it, and allows the bankrupt company to avoid the same through settlement with its creditors and through restructuring plans, and it codifies this within the law itself. So who does the law apply to? Well, the law applies to every natural person in Kuwait, so individuals, merchants, merchant companies, Kuwait companies, and branches of foreign companies. It's not obviously going to apply to foreign companies because that's extraterritorial. It's outside of the jurisdiction of Kuwait. However, to the extent those foreign companies do have a branch that operates, it could apply to that branch. But it's mostly going to be applying to Kuwait companies and individuals. The new law calls for the formation of a financial restructuring committee, which is fantastic because that's going to oversee the management of restructuring procedures, and provide some guidance. It facilitates consensual restructuring arrangements between the debtors and the creditors and tries to build that bridge to a restructuring agreement. It allows for committee-appointed experts to get involved. It's going to maintain a register of insolvencies, It's going to authorize expert fees to these experts that are helping these companies work it out between its debtors and its creditors. And it's going to maintain a list of insolvency experts whose role is going to be to assist the courts for assessing and implementing the chosen insolvency procedures. So whether it's an actual full bankruptcy or workout or restructuring, it's going to have experts and it's going to put a list of these who are going to help the situation. That can be used for the purpose of assessing this and implementing any programs that come out of the insolvency that is chosen to pursue. The law is also going to establish a new bankruptcy court. And I think this is a very key aspect of the law. Now, we talked about earlier in relation to the leases and rents, there's going to be a new rent division of the courts, which is going to alleviate the burden on the general courts, for instance. And this will also help alleviate some burden by having a specialized court. And I think that's one thing we're starting to see turn the corner in Kuwait is specialized courts, and which would be a great thing, because right now what we have, for those who are familiar with the court system, is you file your cases at the court of first instance. Let's put criminal aside. But let's say it's a civil claim, you file at the court of first instance, and it can go to the experts department. Those experts may or may not be experts in the particular issues that are going on. But specialized sectors such as, or areas of law such as bankruptcy or lease or whatever, by creating these new specialized courts, you're really taking burdens off the general courts, and you're allowing experts and specialized judges to make decisions that will really be able to hone in on the issues at hand and apply the law as it's supposed to be done. So I think the establishment of a new bankruptcy court would be a great thing. It is a great thing, and it's one of the key new aspects of the law. It's the first time that Kuwait will have a specialized bankruptcy court. Judgments issued by the court will be enforceable and will not be permissible. It's not going to be permissible to dispute the judgments, and you cannot suspend their implementation except in accordance with rulings of the Court of Appeals. This is the normal appeals process. But once the court makes the ruling, assuming appeals are gone, you can't suspend it. You gotta follow through with it. It's the way it's going to be. Within 5 working days from the date of the bankruptcy judge's decision, the bankruptcy administration shall do one of the following: commence liquidation procedures, publish its decision. It should notify the concerned parties, disclose it on the Kuwait Stock Exchange if it's a listed company, instruct the debtor to disclose it on its website, unless the judge decides that the other methods of disclosure are sufficient. In addition to these things, the new law calls for a preventative settlement and financial restructuring. Now, this is another key thing. This is something that we've been talking about, the theme of, before we get to this end all be all, where we have to wind up the company, liquidate it, start paying out employees, then pay out our secured creditors and our unsecured creditors and go through that process. We have an opportunity to do other things, such as preventive settlement, which provides the debtor with an option to avoid insolvency and allow discharge of debts through creditor arrangements and keep control of its company. So by doing so, it gets to keep control of its company by reaching an agreement with its creditor. Now, these preventative settlements are voted on by the creditor, so a plan must be created. It's going to be voted upon by the creditor. And if you're an affected creditor and you don't like it, you can oppose it. You can vote against it. You can also, after decision to ratify the settlement proposal and before its implementation, you can request that the bankruptcy court order the termination of its procedures, and the court will go through the process of termination. However, once the proposal is approved by the bankruptcy judge, it's enforceable against all creditors, including those who rejected the same or did not show up for the vote. So it's important that creditors take an active role in these bankruptcies, especially in these preventive settlements, to ensure that they are part of a system and come up with an agreement that's workable for all parties. Because the goal, of course, where possible, is to see the survival of these companies, not necessarily the windup. That's not to say there can't be windups and there can't be liquidations based on this, because sometimes you just can't save them. Bankruptcy administration shall announce, publish, disclose, notify all accepted proposals, all rejected proposals, terminated procedures, and can open restructuring procedures or declare bankruptcy within 5 working days from the issuance of the decision. So it's going to have a lot of, the bankruptcy administration is going to have a lot of discretion in this. And again, the goal is to work with these companies to see what's the best way to get out of it. Creditors can make the move to try to force a company into something. At the same time, the company can try to keep its control of its company by requesting some type of preventative settlement or financial restructuring to allow the company to continue on these situations. Other concepts that are brought upon by the new bankruptcy law are there's going to be the implementation of bankruptcy trustees, which oversight the entire process, to act as these trustees. For those that are unfamiliar with the concept of a bankruptcy trustee, act as administrators for the companies undergoing restructuring or liquidation pursuant to the law, oversight it and carry it through its process. So you have an independent trustee that's a part of the bankruptcy administration, bankruptcy court, that oversights and guides this company to make sure everything is going as planned or as agreed. There'll be a bankruptcy investigator that's going to oversight the trustee or the company in restructuring to make sure that the investigator sees what's going on, to make sure everything is going according to plan. And there'll also be a bankruptcy commission that'll be established under the Ministry of Commerce and Industry that'll only be applicable not to all companies, but to state-owned companies and companies regulated by the Central Bank of Kuwait or the Capital Markets Authority, so listed companies, or those that are, I'm sorry, the Central Bank of Kuwait, companies that are banks and other financial institutions. So, like I said in the outset, I think this is a very welcome development in Kuwait. It allows not only for properly specialized bankruptcy procedures, but also codifies, and codes, workouts, and alternatives in order to try to salvage distressed companies rather than, using an archaic system of insolvency to try to do these deals. So hopefully what we'll see from this law, if it is indeed published and passed, which we expect it to be, it's been passed by Parliament, like I said, but it has to be published on further review. Once it does become published, we hope to see that it is used for those distressed companies to try to get them out, to salvage them, and to form a more modernized bankruptcy and insolvency regime within the country. Now, anytime you have regimes like this that are built for this type of things, it also improves on foreign investment, because then companies that do business in Kuwait can say, if I'm doing business with a company and I'm a creditor to these companies, or I have business with these companies, it doesn't mean I'm just not going to get paid someday. There are options, there are rights, and there is a new modernized regime that we can rely on. So it does not only helps the companies themselves, but also improves the business image within the country for foreign investment. The second major law I'm going to discuss, and the last major law I'm going to discuss, is the new competition law. So the new competition law was recently published in the Kuwait Gazette, Kuwait Dilaom, so which means it does have force of law within 1 month of its publication. So unlike the bankruptcy law, it is further along in terms of the process. Provides for new provisions as well as to regulate new areas of the competition practice. So it goes beyond that of the old law, which was issued in 2007 and which was amended, I believe, in 2012. So the competition law is, you could say competition law, anti-competition, antitrust, monopolies, these type of things. For those who haven't dealt with competition before, but we're looking at threats to competition between competitors in the country, so there's no unfair competition in terms of doing business. The old law was passed in 2007, and like I said, it was amended more recently, but was somewhat lacking in a number of areas and details when it was looked at through the eyes of international standards. So the new law provides new provisions and regulates new areas of competition practice that were not provided for under the old law. So it's become a little more specific in terms of the areas that it covers, which is good. Both the old and the new law are based on the EU model regarding competition, so they are somewhat similar. The new law is based upon the old law, which they're both based upon EU models, but the new law tackles more areas of competition-related practice and also enhances the role of the Competition Protection Authority, which is the authority that was established to oversight competition issues in the state of Kuwait. The main difference illustrated by the new law related to regulating new areas of competition that were not expressly included under the old law, such as vertical and horizontal competition practices. Now, you hear this all the time in the competition realm. You have horizontal and vertical practices. What are those? The old law kind of described them, but didn't specifically say what they were. We now have that in law, which is very welcome, because for legal practitioners, it's an important point to distinguish between the horizontal and vertical practices. I'll get into that a little bit. I'm not going to overdo it. I'm not going to over legalize it for you, but we'll get into it a little bit. And it also amends and enhances some of the old law provisions. According to the general provisions of Kuwait law, current competition cases that have been brought under the previous law should be scrutinized under the old law. So those will grandfather in. They should continue under the current regime for laws cases that were situations that were submitted to the Competition Authority prior to this issuance, and then moving forward, you should be under the new regime. I would note, though, that there are going to be, and you'll see as I talk through this, executive regulations that will have to be filed for both the bankruptcy law and the competition law. And that's going to be very important. So until those are issued too, there's going to be some question marks. So here are some new additions to the law. There's some new defined legal terms. For example, defined agreements that may be concluded between competitors that may restrict competition. So the old law did not define these agreements, but rather used a definition of control in terms of market practice. So they looked at, is there control by competitors in the market, as opposed to what agreements themselves can be deemed to be violative or concerned in terms of competition. The definition of the agreement widens the scope of arrangements that may fall under the purview of the new law, such as implicit agreements, verbal agreements, direct agreements, indirect agreements, which may unlawfully restrict or control competition. So before, the key factor was control. Does this party or this company control a certain percentage of the market? Now, we'll look at that as much. We're looking at, do you have an agreement? And does your agreement possibly affect, restrict, or control competition in the country? It's much more broad than just having a strict control test based on a percentage. The new law applies to any practice that takes place inside or outside of Kuwait that may restrict, harm, or negatively affect the freedom of competition in Kuwait. The old law did not provide this broad cover. And that's an important point. So if you did things outside of Kuwait before, and they had an indirect influence in the country, then it wasn't really covered under the old law. However, now, to the extent that you have certain practices outside of the country that directly or indirectly affects competition within Kuwait, the new law is going to cover that. The old law generally provided for exceptions to certain activities from the scope of the application of the law, where the activities did not materially affect the competition. In practice, the application was unclear, led to confusion and disputes within the Competition Protection Authority. So there were certain exceptions before that were allowed to say that if you fall within this exception, you don't fall within the competition law, or this law doesn't apply to you. However, like I said, in practice, these waters were muddied, and it was unclear both to the legal practitioners, companies, and sometimes even to the Competition Authority itself. There's some interesting debates that were had in some of the claims that were filed. So what's the scope of the application of the new law? The new law clearly defines the areas or activities which are not subject to the law. And those are entities that provide public utility services, and government-owned companies that are defined or set forth by the Council of Ministers. So outside of that, you're within the law, and you're going to be regulated. Therefore, the new law narrowed the scope of exceptions and provides a better indication for what is included given its new broad reach. So you're basically included, and it can be anything that you do that may affect competition within the country. So under the new competition law, like I said at the outset, it addresses vertical and horizontal relationships. Horizontal versus vertical relationships are a concept that's used in most competition law regimes, and the old law did not specifically delineate between these two. Like I said, it kind of described it, and in the notes to some of the laws, to the law, it did refer to it. However, it wasn't specifically delineated within the law itself. The new law specifically addresses both of these relationships. So let me boil this down to its very, very basics. So if we look at horizontal relationships, we're talking about direct competitors that are horizontal or on the same plane. So let's say Coke and Pepsi. They would be considered to be horizontal competitors. Then vertical, you look up and down. So for vertical, you might say, using Coca-Cola, it's distributors in Kuwait. That could be a vertical relationship. So it's Coca-Cola not necessarily competing directly with its one of its competitors, Pepsi, but Coca-Cola could have certain practices with its distributors, with its agents, with other companies it does business with that affect competition in the country. So that's the difference between horizontal and vertical at its very basics. Under horizontal relationships, the law lists the types of prohibited activities that are concluded for these types of competitors. These are such as price fixing for goods and services offered within the Kuwait market, fixing the volume of productions, distribution, or sale of goods, so the amount that you're producing, manipulating bids and tender prices through agreement or through price fixing, and restricting technical development or investment producing, selling, buying, or distributing goods or services. So you're looking at things where you're actively doing something that's going to affect your competitor, such as price fixing and limiting the amount of product, or over supplying the amount of product to try to drown out the competition, things of that nature. Under the vertical front, prohibits any agreement between the principal and his agent that may restrict or apply unfair competition practices to the market. Again, it's a very broad standard. Now, when I say principal and agent, don't necessarily think of agency as in like the agency law in Kuwait, or a commercial agent under the commercial law. It could apply to that. Of course, it definitely could apply to that, but it doesn't. I'm using more in a broad sense. So the principal being, the main company and any of its agents, or let's say companies that it does business with. So that's any agreement that it could affect, whether it's price fixing, manipulation of bids, volume of production, all these different things in relation to these will be looked at too, and specific calls for that in the law. So we have the Competition Protection Authority, and as I said, that's the authority that regulates all these issues within the country. And the new law provides, and it's already there, it's already an active, very active body actually, with regulatory body within Kuwait. And under the new law, provides the CPA with more discretion and authority to decide on whether certain activities should fall under the scope of the new law. Exceptions to this application can be requested by concerned companies and will be decided upon by a special committee. So if you think you should be excluded from a situation or from the law, then under your specific circumstances, you can request that the CPA review it, and a committee will make a determination. The competition authority should evaluate the request on a case-by-case basis and render its decision as to whether a certain activity is exempted or not. Therefore, the discretion lies with the CPA. Again, that's extremely important. The discretion lies with the competition authority to make these determinations, not with the companies to decide whether they think, obviously, they're violating, competition laws. So what's the one of the main areas in competition that we've been dealing with and we've seen within the country are in the context of merger and acquisitions, so M&A transactions within Kuwait. So what's the competition authority's role now within M&A transactions in Kuwait? Under the old law, the duty was on the companies to notify the authority and obtain approval when you obtain 35% control of a certain market in Kuwait. There was confusion as to who decides the 35% control mark, how it's determined, and when it should be disclosed: before the transaction, after the transaction, during the transaction. And actually, the old law and its executive regulations had conflicting language in this. So if you looked at the law, it said that the onus basically is on the company to disclose to the authority when it reaches 35% market value. So by that black and white reading of the law, you would say, okay, as the company, I'm going to make a determination to say if I've hit 35% of the market, and if I have, once I obtain that amount of the market, then I have to disclose, which would be after the transaction is obviously finished. However, the executive regulations seem to indicate that no, it should be disclosed prior to obtaining the 35%. So there was some conflict in terms of that and how that would have been interpreted. So we're hoping that this becomes less of an issue in terms of disclosures. Under the new law, it's the same obligation. However, you did not provide for the threshold for requiring the competition authority approval. So there's no 35% threshold. It's just whether or not it's going to, are you taking a market share, and will it affect, you have to make a disclosure. Now, what the specifics are, the devil's in the details, as they say. So what the specifics of that disclosure are, we're all, kind of waiting on pins and needles, as much as anyone can wait pins on needles for competition law. I guess that's what lawyers, we get excited about this stuff, but you may not be so excited about it. But we're really looking to those details about disclosure in terms of acquiring market share. Since there is no threshold, is it going to have to be in every situation? Does every transaction trigger this? How it's going to be implemented? And these are burning questions. Like I said, the new law leaves us up to the executive regulations, which are yet to be issued. Therefore, these critical questions will hopefully be addressed and clarified in the new regs, as there's been critical issues for many entities in M&A transactions in the past that we've been dealing with. So Will this apply to any transaction? How will we know? The reporting requirements, like I said, these are burning questions that need to be answered, and they'll hopefully be addressed in the new regs when they come out. We expect that a pre-merger acquisition notification will be required. If I was a betting man, that's what I would say, is a pre-merger acquisition notification may be required, because that's what we're seeing in other GCC countries in the Gulf. Seeing pre-notification requirements, or at least reaching out to them during the course of the transaction rather than waiting to a threshold is hit. So we think this is where it's going to move, because this is what the other GCC countries are tending to do. In terms of the competition law, because we're lawyers, we always like to end on positive notes. Let's discuss, violations and penalties. Violations under the old law, the penalty for a violation was that it cannot exceed 100,000 Kuwaiti dinars, or a sum that is equal to the amount that was unfairly obtained by the violating party due to unfair competition. In other words, equal to an amount that was obtained by performing the acts that led to this unfair competition. And it could suspend the license of the business to carry forward. Under the new law, the penalties appear to be more harsh, and it's not just one overreaching penalty. They differ depending on the violation. So, for example, there's a penalty that shall not exceed 10% of the total profits that are achieved by a company if violation relates to a prohibited agreement. So, if you had some type of agreement with a company that violates the competition law, then a penalty shall not exceed 10% of the profits that you achieved by implementing that agreement. 10% of the total profits achieved by a company if you disclose misleading information in its pre-merger notification that was submitted to the CPA. So if you submitted information about your disclosure to the competition authority, it was misleading, then you can get again. They're looking to attack the profits you made, by doing business unfairly, and that's what they're looking to do in terms of the penalties. So I'm not going to spend too much time on the penalties on that. So we're a good 45 minutes in now. I think that's about my time. Just to quickly recap, we're constantly on the lookout, obviously in Kuwait for new laws and things that get passed. I think the bankruptcy law and the new competition law are both welcome laws. We already had the foundations for the competition law, but now I think they're fine-tuning it to where it needs to be, just like many of the other laws have done the same thing. You're going to constantly see new laws come out. Like I said, there's always new decrees and regulations being issued in terms of healthcare, data protection, criminal laws, all types of things are coming out. Companies law regulations. CMA constantly is issuing new decrees and regulations in relation to the Capital Markets Authority. So you're constantly seeing these things. Way too much to talk about in 45 minutes or a webinar, but I wanted to focus on those two things because those seem to be the two hot topics in Kuwait right now, and to give you an update on things that we've seen since the COVID pandemic. So I think I'll stop speaking at this point, and I think we're going to have some time for some questions and answers. So I'll hand it back over to Paula.
Thank you so much, Philip. And we actually did get our first question. So due to COVID, can Kuwait government restrictions be classified as de facto change in law, as they are edicts to be followed by contractors?
Good question. Can they be considered de facto changes in law and obviously applied to your change of law clause? It depends how the law is written, to be honest. If the law specifically says that it shall apply and that it should not be considered a change in law, then you would not be able to apply it as a change in law. However, that would seem a little onerous in my opinion. Usually you don't see countries pass laws like that. Too much to say that they're going to pass a new law and say it doesn't classify as a change of law clause. That kind of goes against the definition. So it really depends upon what the specifics of the law state. I'd have to get a specific example, but normally we see that any change in law is a change in law, unless special circumstances dictate in emergency situations. Now, so I can see that potentially happening in a pandemic situation. You'd have to look at the specifics of the new law that would have to say how it affects the current law or changes in the law clause. You would have to define it. Otherwise, you can't really say it's not a change in law in my opinion.
Thank you so much for clarifying that. And another question is, does the competition law apply to all business sectors?
It does. The only exempted business sectors were the utilities, and certain state-owned entities that are disclosed by the council, or that are determined by the Council of Ministers. So it would apply broadly to all business sectors.
Okay, and this goes on to the next question. Do these laws apply to companies that were established in the free trade zone?
The free trade zone, when you say free trade zone, you're not talking about the old free trade zone, you're talking about KDIPA?
No, I believe the old one, the old free trade zone.
I think it would apply to everybody. And the old free trade zone, I mean, that's pretty much gone. So I don't think the applications, much in terms of application to that as a standalone. So I would assume it applies to them, because the new law is very general in its application. It says, unless you're one of those exempt companies like public utilities or one of the state-owned companies, it applies to in Kuwait or outside Kuwait that affect the market. So if you're affecting the market within the country, then yeah, it would apply.
Okay, thank you. The next question is, what are the measures taken from the Public Authority of Manpower for the companies that apply for leaves for their employees during the lockdown?
Oh gosh, I mean, what's PAM doing in terms of for companies that applied like forced leaves? Are we talking about forced leaves?
That's right.
Okay, yeah, it's a good question. It's a burning question too. Just to give some background to everybody, you know, leaves are generally not allowed to be forced in Kuwait. They have to have the consent of the employee. That's why they have the ability to carry over leave for up to 2 years. So generally, you're not allowed to force. There are some debates on there is some amount of time that the local employers can dictate. However, generally, if they're forced, what's the position PAM has taken? From what I've heard, and this is not by court cases yet that we've said, because I know a lot of court cases have been filed, and this may take time to figure out with the courts, but they're encouraging the companies to resolve those situations and not force the employees. However, at the end of the day, they don't have enforcement authority to go in and force employers to do certain things. What they can do is request and try to resolve the situation, and then it has to go to the court. So as far as I'm aware, I haven't seen them rectify that, except they have put pressure, I believe, on some companies where complaints have been made or filed with PAM to ease up on any of the forced things such as reduction of salary or forced leave that are violative of the company's law. Ultimately, though, I suppose, you know, it's going to be an issue of lawsuits before the courts to be determined. So I haven't seen, or I'm not, I mean, other practitioners may have other experience, but I have not seen them take any enforcement action against anybody, suspending just on the threat of that, because you have to prove it. And to the extent that they can prove that they were, you know, forcefully taken leave or reduced the salary, then there should be, you know, repercussions and damages.
Thank you so much for clarifying that. And now there's another question. Talking about mergers and acquisitions, do you expect more of those happening due to the current economic situation and in the finance sector?
I sure hope so. I'm a corporate guy, and at the end of the day, and I've done a lot of M&A work in Kuwait. And I'd say right now, we have a few matters where I think I would say I don't have as much as I would like in terms of or visibility on active M&A deals. However, it's not dry, which is a good sign, because after everything that has happened over the past 9 months or so, to the fact that we are still seeing some activity and potential activity happen is a good sign. So I'm not expecting to see a boom, obviously, in M&A work. However, it will be interesting to see what happens in the next 6 months, because I think we are going to see more companies that are distressed, that are struggling, and to see what happens, whether if we have private equity investment in these companies or whether we see some mergers in terms of that. You know, if you go back to the global financial crisis, you saw a lot of workouts and restructurings, both debt and corporate. I would not be surprised if we see more of that coming forward, but I don't think that this helps M&A deals in terms of traditional, you know, active market. But like I said, I haven't seen it dry up, and we're thinking positive when it comes to M&A work.
I see, thank you. And under the competition law, if the law confiscates 10% of the profits obtained arising from the restriction in competition, then aren't participants profiting 90%? Someone is asking.
I suppose, and I suppose there's other penalties. So if you take 10% of the profits, a penalty of up to 10% of the profits obtained, not all profits. My guess is the theory behind that is that, and I'm not speaking for the legislature, but my guess is the theory behind this: not all profits are obtained, through unfair competition, but there's probably a chunk of it, and that applies to that as a penalty. But let's wait till we see the executive regulations, so there may be more clarification on how they will apply these penalties. And look, one threat under the current law was that they could cease business, and that's brutal. So you got to be very careful. So if that continues to be one of the factors in terms of penalties, then it's not just the 10%, that's the monetary fine. But if they have the ability to continue to shut down your business, then it's much worse than just 10%.
Thank you so much for answering all the questions that we have for now. And now I would like to give the floor to Mr. Frank Balonas, who's our chairman.
Thank you, Philip. That was a very, very good insight on a subject that's very, very fluid right now. I anticipate having you and others back again and us having this discussion once again, and as they continue to modify and change a lot of their laws and regulations. So thank you, Tamimi, and thank you, Philip, once again for this outstanding webinar. I'd like to just
appreciate you having us, and it's
our
always my
pleasure
for the American Business Council and the German Business Council. And thank everyone for listening, and hope you enjoyed it and found it insightful. And people know me around in Kuwait, so if you have any questions, feel free to reach out to me, and happy to answer.
Absolutely. All right, thank you. I'd like to just take a second and just give a really quick update to all of you on the ABCK-AmCham Kuwait, what's going on. We're working very hard behind the scenes right now, obviously representing you, all of our business community, with a lot of the issues that we're facing. This webinar this evening is just one example of some of the subjects that we are regularly paying to both the U.S. and the Kuwaiti governments. Especially right now, we have a lot of dialogues coming up, and our embassy has just been truly amazing with working with us and collecting all of our insights. So there's more to follow on that. Also, I wanted to just take a moment and say, we're still under the constraints due to the COVID when it comes to gatherings, which is something, we're all dying to do. We're all dying to get together and have some kind of events. We keep planning for it just in case. We're looking at creative methods that we can get around it to still be safe for everybody. But we're still working through what policies are in place. So right now we're still delayed on it. Hopefully soon we'll be able to all get together in person again. But in the meantime, we're going to continue to plug away and provide valuable information like tonight through a lot of our webinars. And there are several things coming up just and by the way, they're all on our website. So please take a look at our website. We blast them out on our social media and on the internet. So they're all posted. But this month, from the 16th to the 20th, we have the Cybersecurity Virtual Fair. On the 17th is the 4th Annual U.S. Kuwait Virtual Economic Forum with the U.S. Chamber. We've been in correspondence with them about a lot of that. We have scheduled the 19th for a Thanksgiving thing, but it looks like that's going to get pushed back yet again because of the restrictions that we're facing. But something that's very unique, and I hope you partake in, is on the 24th, we're going to do another virtual speed networking event. If you didn't participate in the last one, it was the first try we ever did on something like this. And it actually became extremely successful, and we got a lot of positive feedback on it. So please plug that one in on your calendar. It's a great opportunity to network with the business community and with all of the members that are out there to be able to correspond with one another, share your company and what you're capable of doing, do some BD, so on and so forth. It's a great opportunity. So please partake. Again, I want to thank Tamimi Group and Philip for this amazing event this evening. I thank all of you for participating with us tonight, and I thank the German Business Council for being here with us this evening. Wunderbar to have you guys with us. And again, thank you all. Have a wonderful, wonderful evening. Thank you.
Thank you so much.